Good afternoon, and thank you for joining us today. I would like to welcome you to the Fortney Scott webinar entitled Federal Contractor Compliance Update, DOJ, EEOC, and DOL. This webinar will be recorded. Today's presenters are Fortney Scott attorneys David Fortney, Nita Beecher, and Elizabeth Bradley. I will now turn the program over to David to start the webinar.
Sarah, thanks so much. And hi, everyone, again. Great to see you. I hope you're having a wonderful summer. Liz and Nita, how are you both doing today?
Doing very well. Happy to be back in DC.
And it's another beautiful day, very hot here in St. Louis.
Yeah, another very wet one in DC. So here we go. Well, listen, as Sarah indicated, what we want to do is give you an update. For those of you that are not familiar with us, we are, of course, a Washington, D.C. based law firm, and our practice really focuses on exactly what we're going to be talking about today, developments involving U.S. Department of Labor, the Equal Employment Opportunity Commission, the National Labor Relations Board. We have the privilege of representing a number of clients that have issues and compliance challenges involving all of these agencies. And our practice is very broad-based and includes federal contractors, non-federal contractors, covering the full range of workplace matters. So with that, why don't we just jump right into what has proven to be a really, summer is sometimes the doldrums, but not so much this year. So we've talked a lot about Executive Order 14173. That's the order that rescinded Executive Order 11246 and talked about illegal DEI. We want to talk. There have been several significant updates, and we want to make sure all the contractors are up to date on that. The DOL budget, proposed budget for 2026, talks about the possible elimination of OFCCP. We want to unpack that a little bit. June 27th, the OFCCP Director Eschbach sent a letter requesting voluntary data submission, kind of a new approach, has a lot of people scratching their heads and raises perhaps more questions than it answers, but we want to unpack that. Right after that, we have the Secretary's order that relaunches 503 and VEVRA investigations. Then there are proposed regulatory revisions and some final thoughts. Yeah, that's about 5 hours worth of material, and we're going to do that in 60 minutes and not sound like a FedEx high-speed ad. So with that, I don't want to waste much more time. I want to really jump right into the implementation of 14173. So let's jump into that. And Nita, maybe you can kick off our discussion on that, please.
Well, I'm sure almost everybody who is watching this webinar is very familiar, or at least somewhat familiar, with all of the implementing opportunities we've been seeing on 14173. DOJ obviously has rolled out its civil rights initiative at the FCA situation. EEOC has issued numerous guidelines for employers to follow. DOL, obviously now with OFCCP, is doing similar things. I think the most interesting thing, and I'd like your all's thoughts on this as well, is the non-traditional workforce agencies and also agencies that are regulatory in their nature have been utilized also to implement 14173 and eliminate DE&I. And I have a very recent, as of yesterday, T-Mobile said, we are eliminating all DE&I, so the FCC will in fact approve a merger they're having with two different organizations. I think that is fascinating, David and Liz. What do you think about that?
Yeah, I mean, this I think is a really key point, and this is so different. For those of you that have thought about affirmative action and compliance with the EEO laws and thought traditionally about either the Labor Department or the EEOC as being the compliance agencies, in the Trump administration, what we're now, I think we need to recognize and appreciate is the illegal DEI standard has become an animating principle, kind of the pole star that is guiding all sorts of agencies, regulatory agencies, approval. You mentioned the FCC, merger approvals. We've seen the HHS fielding complaints on a wide range. And all of these, even though illegal DEI wouldn't traditionally be viewed, and it's not even clear that it's in their wheelhouse, as a practical matter, the agencies are saying, if you have even a whiff of illegal DEI, and let's just say that we have air quotes around that term every time we use it, it's not our term, it's the administration's term, that they're using that as an animating principle to justify regulatory either disapproval or putting additional requirements on for transactions or other efforts to occur. So I think that's very significant.
I think you also see this, and we talked about this before, in the EEOC's letters out to the 20 law firms. And, DE&I was that. And the only way those were resolved basically were to go to the other thing that we think is really interesting is the White House controls everything. And I think that's the other piece that we're discovering in order for, back in the day, like the first Trump administration, the EEOC would make their own decisions about settling things. When it comes to DE&I, that is not what is happening as far as I can see, Liz and David.
Yeah, I agree. I think, before EEOC what we are hearing is before EEOC can agree to any sort of resolution, that has to go through the White House, and that the actions and any potential resolutions are being driven through the White House. And that is unprecedented. That's not the way the commission has operated in the past.
Yeah, and I think that's a perfect example, David, don't you think, of what we're seeing in this administration, which is unlike anything we've seen, certainly in the period that I've been working in this world, this field here.
Well, the level of coordination, every administration talks about coordination. There traditionally have always been fairly siloed agencies, and they sort of do whatever their particular area is. That is not the case in Trump 2.0. And I just want to underscore that certainly it appears that the evolving pattern is if it's an illegal DEI related issue, there's a White House nexus, some level of approval, sign off. Certainly we have some familiarity with some of the issues involving law firms that have faced, and we have certainly seen that there. I'm not sure that's true for every garden variety claim, but I think that for these that have any component of alleged illegal DEI, there's folks in the White House who are apparently going to have to sign off on it in some fashion.
And remember, there's that May 21st list, which I'm sure we'll be talking about, of egregious DEI practitioners that's out there.
Right. And just to refresh people, Executive Order 14173 imposed a requirement that by May 21, the federal agencies would have compiled a list run through the Justice Department and submitted to the White House. Even though that list has not become public, our best information is that in fact the list was compiled, dutifully compiled, is worked on by the Justice Department. It was submitted to the White House, specifically to Russ Vought, the head of OMB, excuse me, and Stephen Miller, the deputy domestic policy advisor. So in any event, those changes are there, and that creates also some overlay of anxiety and uncertainty. We've got clients that are like, do you think I'm on the list? Am I not on the list? What do I do to get off the list? How do I find out if I'm on the list? Those are very challenging questions to answer at this point.
Well, going to the next slide, Liz.
Let's move into some of this.
Further on the implementation of the executive order, the certification requirement, as you recall, 14173 required that contracting agencies put in a new certification requirement into contracts, essentially certifying under penalty of False Claims Act liability coming in, that programs do not have any DE&I or other programs that violate federal anti-discrimination laws. So those are being rolled out, and we're seeing those coming out of the various contracting agencies. So something to be mindful of, and I know federal contractors were thinking of the OFCCP certification that was a single portal That's not how this is happening. It's coming out from each of your contracting officers. So if you have multiple contracts, it's coming out from whoever is the primary point of contact in the government for each of your individual contracts. And we're seeing it come out in various different ways. We saw the provisions in a request for proposal. So at the beginning of the process, makes sense to be in there. But then we've also seen it for existing contracts come out through a contract modification, but also as informal emails saying, are you willing to agree to this? So you need to be looking for it, and you need to be letting your procurement team know, hey, this is coming in. We don't know exactly how it's going to be coming in. And it's really important that you be letting legal, procurement and legal need to be talking on these pieces, because the False Claims Act liability associated with this is a real concern, and you need to be it's not just another FAR provision that you're signing off and agreeing to. We're also starting to see prime contractors flow this down to your subs and asking subcontractors to sign this, again, through contract modifications or simple emails. Really important. Currently, the only source of law requiring these certifications is the executive order. The executive order does not contain any obligation that primes flow it down to their subs. So be mindful of that if you do not want to agree. If you are a sub and you do not want to agree to these provisions, you have grounds to push back on right now. So there's been no regulatory guidance or any other guidance that has said subs have to be subject to these, or you have to flow it down. So think that through.
But that may be changing.
That I was about to say, David, but there's an OMB interim final rule and FAR provision.
Well, there is, and that may change, because the process that Liz described has been very chaotic at this point, and it's affected international locations, a lot of embassies. The State Department appeared to be one of the frequent flyers, and even certifications that had grammatical errors in them and so forth is ridiculous. So OMB, there was posted a proposed rule, and this was what was called an interim final rule. That's, although authorized by the Administrative Procedure Act, that's somewhat of an unusual step. Basically, what that means is the rule is not controversial, it's pretty standard, and we're going to publish an interim final, meaning the final rule with no prior opportunity to have it published for comment would be published and put into effect. And then if there was feedback on how to adjust the final rule, it would be received while the rule's in effect, and the rule then could be tweaked or modified if necessary. When do you use interim final rules? Normally, it's if you have, I'll call it housekeeping. A law has changed, some requirements have changed. It used to be 180 days. Now you have 365 days. Okay, simply making the administrative change from 180 to 365. That would be certainly an appropriate use. The OMB description of the rule does not publish the rule, nor does it describe it with detail so that we actually know what the final rule is. To be clear, we don't know. That's not public. We had believed and understood that the final rule was probably initially thought of as one to simply remove references to 11246. That would be a housekeeping type of change. And that would be something because the federal acquisition regulations, the FAR regulations, contain a multitude of references to compliance with 11246. It's been rescinded. We should redact and remove those. Perfect opportunity to use an interim final for that housekeeping. But we think that some of the other regulations, and there's been a lot of feedback because the OMB holds public meetings on these, even though it's an interim final rule. We have participated in a meeting with OMB. I will tell you, even though DOJ and so forth prides themselves on being very forward-leaning in technology, this was so old school. This was like circa 1992. I mean, we're back to the original Bush administration. We had a dial-in call. It was like, hello, is Ronald Reagan on this? No, I don't think so, but here we go. We had a dial-in call to talk about what the concerns were. And in that call, we proposed on behalf of the Institute for Workplace Equality, a safe harbor for voluntary contractors to deal with the certification. And the safe harbor basically has three basic steps: review your policies, check and see how those policies are operating, and if necessary, make any corrective changes so that you don't have illegal DEI and you do not have any unlawful discriminatory practices. Something that most of us are doing anyhow as part of just, I'll call it compliance hygiene 101. And in exchange for that, if you did that, you would be able to, under our proposal, to certify on the SAM database that I'm in compliance, so therefore you wouldn't have to do all these individual certifications. You'd be a contractor of preference. And importantly, the Justice Department would agree it would not pursue False Claims Act claims against you for illegal DEI, and it would oppose any private False Claims Act claims filed against you. And finally, that the EEOC would not bring any Title VII pattern and practice claims centered on the FCA. So it would be a very powerful safe harbor, very beneficial to contractors. We don't have feedback on that. We, by the way, have also proposed it to the task force that we're going to talk about in a moment here. But it is something that we're trying to deal with the realities of: is there going to be a standard certification? Is there a safe harbor, a way to comply? And can we go away from what Liz just described? What is this kind of crazy ad hoc environment of people not knowing what they have to certify, have to flow down, et cetera, and to get all of that in order. And by the way, we'd like a safe harbor for those of us that really are focused on compliance and doing a good job.
Well, David, we also have the Civil Rights Fraud Initiative, David and Liz, which DOJ has rolled out as part of their implementation of 14173. And I did want to mention one last thing, and we've talked about EEOC, and we have commissioner's charges. And oh, by the way, I saw this morning they have scheduled Brittany's, the new commissioner hearing with the HELP committee has been scheduled. So soon, Andrea Lucas, once she's confirmed, will have enough quorum to start really implementing more lawsuits over what they consider to be illegal DE&I.
Can I just say one thing about the Civil Rights Fraud Initiative? This is very broad-based. This is not just the Justice Department Civil Rights Division. They have directed, the administration has directed every U.S. attorney to prioritize False Claims Act prosecutions under illegal DEI theories. So they are directed, the U.S. attorneys are, and this is complemented with reach out, where they are publicizing whistleblower, encouragement of whistleblowers to contact the U.S. government. Let them know if they think that there's any illegal DEI going on, training, promotions, hiring practices, anything that someone believes. So we're not talking about filing a Title VII charge. We're talking about going to the Justice Department, broadly cast, including every U.S. attorney and assistant U.S. attorney, who now has this as one of their top priorities to investigate and to prosecute False Claims Act claims. So compliance with the illegal DEI requirement is critical. And it's one where I think the legal risks are quite great. To our knowledge, there have not yet been any False Claims Act claims prosecuted, but let's keep in mind, this is barely 30 days old. I think it's just not a question of whether, but when, and I think it's going to come sooner rather than later.
Agreed.
Well, here we are. Let's go to the next slide, David. Are we in the last gasp of OFCCP?
Yeah. So I'll jump on this. I everyone kind of looks at the budget and goes, "Oh my gosh, they're zeroing out OFCCP," and yes, that's what the proposed budget says. And of course, it makes some basic changes. It talks about transferring VEVRA over to the Labor Department. The Labor Department has a separate agency dealing with veterans. And so VEVRA would go there, and 503 would potentially go to EEOC It's interesting because Congress has assigned that statutory responsibility to the Labor Department. So whether that has to require congressional action or an MOU, or whether that can in fact occur independently. But I just want to remind people, proposed budgets often don't end up as they are proposed. And the last couple of years, and I don't care who's running Congress and who's running the White House, we have seen budgets not be enacted by October 1, which is the beginning of the federal fiscal year. So you have a continuing resolution. That just means whatever last year's budget was just continues at the same clip. Budgets also, through the process, congressional process, get changed a lot. Think about all the changes in the big, beautiful bill that received a lot of attention as a reminder of how robust the discussions and changes can be between the House that originates spending bills, Senate review, and ultimately a conference. Every one of those junctures is an opportunity for change. Many people have differing views on what should happen to OFCCP. Some in the White House believe it should be zeroed out. Others, of course, want OFCCP left unchanged. Others, it appears, may have a different mission in mind for OFCCP. You know, it's not clear, for example, is there going to be a civil agency like an OFCCP to enforce these new illegal DEI obligations, separate and apart from False Claims Act activity? Certainly some of the stakeholder groups who have advocated for illegal DEI, and I'm thinking of America First Legal, I think would love to see, and they have publicly stated, they would like to see OFCCP policing contractors' efforts. And I think we're starting to see a little bleed over in that direction.
Do you think that that's, if we go to the next slide, do you think,
Yeah.
Liz, that's why we got this letter from the current director?
Well, right. So, to David's point, while the budget says it's zeroing out, it looks like there's some activity that the OFCCP is going to be undertaking. So I wouldn't count them out yet. So on June 27th, we get the federal contractor community got a letter from the OFCCP director, and she is stating that under EO 14173, OFCCP has obligations to ensure that federal contractors are no longer complying with 11246. They're no longer engaging in workforce balancing based on protected characteristics. And in this letter, she is asking that the contractor community voluntarily submit information to see what actions they have taken in response to 14173. The content, format, and decision whether or not to comply is voluntary and is up to the contractor community. But there's a lot that we need to consider on this. So moving to the next slide, let's look at what is being asked of in this letter. And the words of this, there's kind of two parts of this. First, they're asking that you state that you have reviewed your 11246 affirmative action efforts, to share whether you made any modifications and that were necessary. And if so, what were those changes and what steps? So they kind of want to see the process that you went through. But if you look further down in the letter, it goes beyond just 11246 required actions, right? So part of it is looking at, did you engage in did you engage with the diversity organizations to become a top worker in diversity? But that wasn't a requirement of 11246. That was a program that people did under their DE&I initiatives. Similarly, mandating certain training courses. They're asking, are you still doing those, whether they're continuing? So while these three items in the letter appear to be focused on 11246, the body of the letter goes much further than 11246 and was wanting to get to all of your DE&I efforts.
That makes me really nervous, Liz. Doesn't that make you nervous?
Well, there's a lot of it that makes us nervous, and I think we're going to get into that in a minute. But I think one thing I want to be mindful of as we talk through this, and I'm going to this is kind of my drumbeat on this one here. We have until September 25th to submit anything. This administration, things happen quickly, they change quickly. What is a decision today may not be a decision tomorrow. A little bit of that we saw with some of the law firms and initial responses to EEOC, and then the backlash on that. So we need to be thoughtful and mindful and walk through all of the considerations that Nita and David and I are going to walk through here in a moment with regard to some of the questions here. Be mindful and let's pause, think through it all, and use the time that we're being given in order to develop a response strategy. I think is going to be the most prudent course here. So if we can move to the next slide, there's some this hits on, I'll let kind of Nita talk to this, or Nita or David, but we felt that there was some lack of clarity in this letter, but apparently we were wrong.
Right. So we didn't find the letter to be crystal clear. Under the banner of the Institute, we wrote a letter. Of course, OFCCP, some things don't change. It issued the letter on a Friday afternoon. Okay, same old, same old. So Sunday afternoon, we sent something back saying, hey, what's this mean? And can you come explain this? We'll stand up a public webinar. We'll have a thing and everyone can come. Anyone who's interested, great. So the response came back very quickly this time in really at the beginning of the business day, so almost 12 hours later. But note here, OFC's reviewed your request for a meeting this week, but believes at this time the letter speaks for itself. The letter speaks for itself. Okay, well, that's lawyer talk, but it also means we're not going to explain anything. The letter is just, we think the letter is crystal clear. Your directions are just perfectly laid out for you. Jump onto it. And you got till the 25th of September. What are you talking about? I mean, that's the gist of what when I got that response, other than going, are you kidding me? Okay, that was my response and take on it. But
David,
David,
honestly, is this different, to be honest? Is this different from anything this administration has done around DE&I? It's left things unclear.
Correct. And I think, Nita, to that point, I think that the lack of clarity is intentional. Because it is understood that often this ambiguity promotes people to perhaps take greater actions in response than they otherwise might, out of fear, out of concern that they not be caught sideways under a False Claims Act or an EEOC claim or regulatory approval claim. I mean, there's a lot of levers. People have grants. People have a lot of different ways the federal government can make their life very challenging. So organizations, we feel that from our clients. They're like, okay, I don't want to be on the wrong side of anything. What do I need to do? And I think that mantra, there's great awareness of that. And I think the White House views that as a positive, not a negative.
If you look at the letter too, Liz, she even makes a comment about how pleased they are with the voluntary response the federal contractors have made, around transparency and so forth.
Right. But so going to the next slide, let's explore some of those, the points where we need additional clarity. And Nita, do you want to lead off with the discussion of the jurisdictional questions?
I am going to defer to Mr. Fortney on that one.
Sure. Okay. So this is, even though the letter speaks for itself, it's a voluntary letter, a voluntary data collection. Normally, when the government engages in data collection, it has to have a Paperwork Reduction Act approval, authorization. They go through what the burden is, what the benefit is to the government collecting the data. So and that's because when the government collects data, they have some bases under which they're justified or required, typically a statute or an executive order that says, collect this information, monitor, assess. That's basically why the government collects information. Let's be clear. There's absolutely no government requirement to collect the data. Now, an agency can say, hey, voluntarily, which is what OFC has said here, if you want to give us the information, we'd love to have it. And that's effectively what's occurring here. But it also makes it a little challenging because, again, any other information or data collection request, the government publishes what data it's collecting, why it wants it, what it's going to do with it, et cetera. Think about pay data collection or EEOC investigations, et cetera. We don't have any of that. It's just if you voluntarily want to give us some information, please share. That's effectively it. There's no legal jurisdictional predicate for doing that.
Well, and I think let's take the next step, Liz and David. OFCCP is supposed to die 5 days after this. They're supposed, so where is your data going? Who's going to get it? How is it going to be shared? I mean, if we go back to DOJ, I mean, we know that there is an effort within the government to share a lot of data among agencies. We certainly expect with MOUs between OFCCP, EEOC, and DOJ, they would clearly share the data with those two entities who do not have necessarily federal contractors' best interests, shall we say, at heart. And then,
Well,
David, I'm sorry, go ahead, Liz.
Well, so I was saying, the receiving entity, even if OFCCP doesn't go away, right? That's the thing is, we have that thing, the response deadline is 5 days before it's supposed to go away. The budget is a proposed budget, so that may not happen. But regardless of that, even if OFCCP continues, there is that concern of how broadly will the information and data that you produce be shared. So it's not only a concern based on the budget.
Exactly. And then confidentiality, David.
Well, confidentiality, and this kind of goes hand in glove with what OFCCP does with the data. To start with, FOIA. We all are very familiar with Exemption 4. There's been a lot of litigation and consternation over EEO1 compelled data collection reports and whether those could be disclosed by the Labor Department under FOIA. There's always FOIA requests from interested stakeholders, activist groups, plaintiffs groups, you name it, shareholders that want the type of data. It does not appear to us that the voluntary data that you opt to submit would be guarded at all by FOIA. FOIA so the default rule is whatever the government has, it shares. If someone asks, they say, here it is, here, you can have it, we're the government. FOIA is a set of narrow exemptions. This doesn't appear to qualify under any exemption. It's not part of an investigation. It's not part of an enforcement activity. It's just a voluntary data collection. So you cannot, even if you mark it confidential, as we typically do, and we do all those steps to try to protect it, I don't think that any of those rules are in place for what would occur here for this voluntary data submission.
Well, let's say one other thing. I'm sorry, go ahead, Liz.
Oh, I was just agreeing completely. I mean, I think,
yeah, go ahead.
I think the FOIA request is going to go in on September 26th. I mean,
I think so.
It's already drafted by somebody. I mean, I'm sure of it. It's coming.
Yeah. Well, one other thing about that. Let's think about that. We were talking about sharing the data. So we're talking about the use of the data. That's another thing. Who is going to see the data? What are they going to look at the data for? I mean, we have to assume certainly DOJ is going to see the data. The White House is going to see the data, and perhaps the White House would share the data with private entities that are closely connected with the administration. So I think that's another, whatever data you submit, it's not going to be protected, and you don't know who's going to use it and for what.
You also have to be a little bit careful about any potential liability that could arise out of those submissions if it is found to be your statements are not completely true and accurate. So you need to be very careful about what is said in any of those statements, even if it's not underlying data. What are the representations you're making in that submission to the government? So that is another significant consideration we need to be thinking about, especially with light of the eagerness to be proceeding with False Claims Act.
And Liz, as a reminder, that's a great point. And as a reminder, there's a presumption that when you provide information to the government, that it's done with an assurance of truthfulness and accuracy and completeness. So it does set up so you submitted a false information, which is the predicate, one of the key predicates, of course, for an FCA claim.
Right. And thinking about this, you need to be careful. some of the stuff you may say you have carved back for 11246, but are you still required to do certain things for state or local obligations? So being careful about what you would say. But everything that David and Nita have gone through right now just kind of led you to believe, why would I ever produce anything? I'm ignoring this request. But please hold. What is that the gotcha that they're saying, oh, nobody's going to want to respond to this? And then are we going to end up with a list of the non-responders?
I'm sorry, Sarah, let's just jump back to a slide. Yep.
Oh, sorry.
Keep going.
Sorry, didn't realize that. Are the non-responders going to end up being on a list of potential DE&I practitioners? Are they going to use, because remember, OFCCP has been collecting your certifications for the last number of years saying, I'm certifying, I'm in compliance with 11246. You're going into the portal, you're clicking the box there. They've extracted that. There's probably an Excel spreadsheet of your names with a checklist. Did they respond to this voluntary? How are they going to use that? What are they going to be doing? So I think that is a really another consideration of what are the potential repercussions of not responding. And these are all those points of clarity that we still need to understand. And so maybe are we getting to a point where there's something that we can submit without too much data, without saying too much, that at least gets us, we've responded and we're saying we are we're in compliance with 14173 without fully going in saying, and we unwound everything that we're doing. So I think there's significant considerations here and weighing of how do we walk the line.
I agree with that. I think that, this point, how you approach this, your organization approaches it, may depend on your relationship to federal contracting.
Yeah.
Some of you participating today, your organization, your company, is effectively 100% a federal contractor. There's a lot of motivations to keep the customer happy, to interface effectively, to appear to be responsive in a positive way. Others are primarily commercially focused, may have federal contracting as a kind of a relatively small component. That may animate how responsive or non-responsive. And second point,
Yeah.
I want to highlight Liz's point, which I think is an excellent one. The Labor Department has a list of every contractor that came through the portal. There is a presumption that all of them were locked into what this administration believes may have been illegal DEI. That's how they view compliance with 11246. I don't agree with that legally, but that's the mindset. And so to the extent that those that previously registered that they had certified compliance with 11246 and don't take advantage of an opportunity, if I were the Labor Department or any of the agencies wanting who should I prioritize to double check and see what's doing, why wouldn't I check on those? It to me seems like an easy way in the era of limited resources. They didn't even bother responding. Maybe they're trying to pull one over on us. I don't know.
Wait a minute. Oh, and we have the May 21 list of these names. And now we look at this and they did not voluntarily notify us that they're no longer,
Right.
Because remember, we were talking about before, there is coordination with this administration.
Right.
So these
Coordination and great suspicion. Great,
Correct.
suspicion.
So these actions are not disconnected. So are they going to be, they have the May 21 list, is one of the ways they're going to whittle down who to focus on the May 21 list, saying, oh, well, that company's on the May 21 list as a prior bad actor, but they voluntarily submitted so we'll move them down and deprioritize looking at them. Maybe I'm seeing, shadows behind the walls, but I think it's something to consider.
I don't think so, though. I mean, I think that's a really good thing to consider because remember, back when we first did the certifications with the federal contract, when for 11246, the idea is that you wouldn't be audited if you certified. So it would be a natural reaction to do that very thing. So we've got a lot still to cover. So let's go to the next slide. And meanwhile, we have more stuff coming out from an agency that's supposed to die in 90-ish days. I mean, seriously. So we get this order issued on July 2nd. So we had June 27th. Now we have July 2nd. They lifted, they called it abeyance. They lifted OFCCP not being able to conduct investigations into complaints. So we're just talking about complaints under Section 503 in VEVRA. They will resume those right away. They will process any ones that came in the time being. But I think the most important thing is that they are not going to continue with any pending compliance reviews because they see those as interwound with, obviously, as we also would agree, 11246. Those are all going to be administratively closed. And as we understand it, anything that was on that November of 24 list will also be administratively closed. Those will not be moved out. But they did say, interestingly enough, I thought, considering what we'll be talking about shortly, that contractors are obligated to comply with 503 and VEVRA as it is now, and it's
Yeah.
implementing regulations.
Yep.
Thoughts, folks?
Well, so I mean, I think, anybody with an open compliance evaluation, you already received the 11246 closure letter a while back. You're now going to, and it's probably going to take a beat. So don't get nervous if you don't see, but the 503 and VEVRA sections are going to be administratively closed. And yes, to Nita's point, any of the CSALs, if you have a location on a CSAL that the audit hasn't opened yet, don't expect an administrative closure on that because they haven't been opened yet to be
There's
closed.
nothing to close.
So they're just they just won't launch at all. I think I do think that is good news I know a lot of clients who had those pending 503 and VEVRA compliance evaluations were monitoring. Well, if the 503 goes to EEOC and the vets goes to vets, are we going to be splitting those evaluations? So I think that is some good news for the contractor community that you're not going to be facing the audits by two different administrations or two different agencies. So I think it's a bit of a good news there.
So, but Liz, we have more. The next slide.
We have
more from the dead agency.
Well, but so this was somewhat expected, right? So on July 1 in the Federal Register, they issued a rescission, regs rescinding the Executive Order 11246 implementing regulations. This is housekeeping, essentially, because with the revocation of 11246, the underlying law that supported the implementing regulations went away. So in essence, those regs were no longer in effect. A little bit of a surprise, there were some modifications to 503. VEVRA, again, is some cleanup. So if we want to look at the next slide, a little bit more detail about the 11246 modifications. Here's a lot of words here, but so this is just showing you, as expected, entire sections were just removed and reserved from the CFR for the regs underlying 11246. One thing to note here, Part 30, 60-30 is going to ultimately be removed. Right now, it has some administrative pieces that are tied to 503 and VEVRA that we're going to talk about in a minute are being moved under 503 and VEVRA. Once the 503 and VEVRA modifications happen, Part 30 will also be removed and reserved. But the one notable piece of the regulation changes here is the removal of Part 60-3, which is the Uniform Guidelines on Employee Selection Procedures. This is the only place that these are part of regs. EEOC uses them as guidelines. They are not regs. So this is the only place where federal contractors were required to comply with the uniform guidelines. So David, do you want to take a minute and talk to us about what the impact this is going to have on federal contractors and sort of
this to me is interesting, and I'm not sure we know fully what the consequences of this is going to be. So let's start with that. Now, the uniform guidelines, all the way back to 1978, they were developed by 4 agencies, what we today call OPM, the Justice Department, the Labor Department, and the EEOC. So now we have one of the 4 agencies basically, and Labor codified them as a substantive reg, not as a guideline. So that was the difference. It was what we call a legislative reg. It wasn't just publishing guidance. So federal contractors had an obligation under the uniform guidelines. Obviously, from a federal contractor perspective, that is eliminated. We understand that. The questions that we don't know, we have a lot of judicial decisions under the uniform guidelines that have recognized that under Title VII, it is a defense if the employment practice is for business necessity and it's no other alternative available that has lesser impact, and that you can effectively validate it or justify it in that manner. And the courts have recognized that if you did that in advance by compliance with uniform guidelines, it effectively created a legal safe harbor. Now, federal contractors had the additional benefit by saying that isn't just up to you, Judge. There's actually a regulation that recognizes that level of protection and safe harbor. One of the questions that we're starting to unpack, and I can't say we have a definitive view on it yet, is, okay, now we have guidelines, not regulations, just guidelines. Are the courts in the current environment, how much deference after the rescission of the various judicial precedents that the courts were to give deference to agencies, how much deference, if any, will a court give to the uniform guidelines? Okay, we don't know, but I can imagine a number of courts saying, what do I care about these guidelines? I can read the statute and either it's okay or not okay. Now, I think there's still ample room for experts. I still think validation is a critical process for employment practices, and perhaps it's even more important as AI requirements come online more, changing regulatory environment involving AI particularly. But this area, I think the impact, because most of you on this call are federal contractors, and I think the lack of a regulation that gave us greater legal confidence in our safe harbor may be significant. So that's something we're beginning to look at, and I'm very focused on.
And I think from a legal standpoint, yes, the other concept may be, with this no longer being a reg, is it going to provide an opportunity to modernize how assessments are validated in line with how the modernization of assessments? So maybe letting this go may allow for modernization technology advancements. So trying not to, it could lead to some improvements in the area. So
right. I mean, for the folks that go to PSYOP, for example, this could be an interesting opportunity to reimagine.
Exactly.
If you didn't have the 1978 guidelines as your guardrails,
that didn't even imagine AI.
Right, didn't even. How could you appropriately validate in the broadest sense and to meet these legal standards under the statute? So it could be very empowering. It's not necessarily negative, but this is potentially more than housekeeping. This is
a landscape change
for today. It's a landscape change, right? Yeah.
Well, let's turn and just see what they did do on 503 quickly, as we are starting to wind down on this webinar. So they didn't just do housekeeping in 503. We kind of expected them just to eliminate, 11246, but they didn't do that. So first of all, they are eliminating the requirement, which we all remembered when this came out in 2013. They're eliminating the requirement to collect self-ID data from applicants. We objected at the time. We said we were concerned that it violated the ADA. And if you look at the statute itself, not the regulations, but just the statute, there's an argument there that it does violate the ADA. Now, if they're moving 503 to EEOC, that may be part of the reason that they wanted to eliminate it. Because they're proposing to eliminate the self-ID collection, they're also going to eliminate that you have to document that annually, but you still have to assess your outreach and recruitment. And in a minute, I'm going to ask these two how they think we do that. The other thing they're eliminating is the 7% utilization goal. We yelled and screamed about that at the time as well. But they are saying because it uses the 11246 job group structure, they are eliminating it for that reason. And then, of course, the more housekeeping 11246. And they also are moving the administrative enforcement provisions into 503. So let's go back. What about this whole issue of retaining the assessment without any data? What do you think?
It's going to be
Liz?
tough. It's going to leave you, but I think it's going to put more work on, depending on how it's enforced. But I think what it's going to look like is your talent team needs to be making sure they are doing outreach and recruitment to disability-based organizations. You're not going to necessarily have data showing that you won't have data showing you have more individuals with disabilities applying because you're not allowed to ask. But you can potentially, if you have a way to collect data about how candidates came in, we know that's not always reliable, but that's one point you could be looking at. You should be keeping records and tracks of the outreach that you are doing and partnerships with disability organizations, the fairs, the engagement there. It's really going to become the boots on the ground work to engage with those organizations and then documenting it so that if you're asked in order to show what you're doing there, you can document it. But it is going to be hard to really do a quote assessment. I
Certainly
don't.
not the way that we've done them in the past.
Correct.
We
Correct.
would use as a yardstick the efficacy based on self-identification data. And we could say, look, here's, folks that came in that were applicants. So we increased our applicant distribution vis-a-vis disability. So, yeah.
These comments are due on September the 2nd, and the Institute will be sending in comments on this. And then the last slide before we conclude, Mr. Fortney on VEVRA.
Yeah. So basically my takeaway on this is we really don't have any changes. I mean, the VEVRA is largely, even though there are all these other changes that have been talked about, yes, there's the housekeeping that we've talked about vis-a-vis any tie on to 11246, but the otherwise VEVRA is as it was before. And so I think that in terms of contractors understanding that, there's really effectively no change in your day-to-day administration and compliance vis-a-vis protected veterans.
So collecting self-ID and you still have the hiring benchmark. So those components still stay in place. Very important.
Correct.
And it is interesting, Liz and David, OFCCP has not updated the hiring benchmark this year. Normally they do it in March. And so I assume we still have the same one we had last year.
I guess so. I mean, why do you think that is? Just busy doing other things, or
maybe
some
they're
had
moving
viewed
it
as
to
maybe
vets. I don't know.
I don't know. Some had viewed it as maybe an indicator they were going to unwind the program, but that would have been surprising to me because I don't care what political stripe, everyone supports vets. So
I may be thinking that, all enforcement activity was held in abeyance following the issue of 14173. Arguably, reviewing and resetting the hiring benchmark possibly was within the scope of tasks that were held in abeyance so now maybe with the secretary's order saying there's the lift on the abeyance of doing investigations and some of the other work, maybe some of this housekeeping matters will move forward as well. Just a thought.
One other thing I wanted to mention from this agency that's supposed to be dead on October 1 is they have asked OMB to give them an emergency update of their complaint to eliminate the 11246 aspects, which I thought was really interesting. And that, again, just came out to basically so that people will have an updated complaint form with 503 and VEVRA only.
Okay, well, let's go and share some final thoughts. Nita, maybe I can ask you to jump off on that, then I'll go to Liz, and then I'll go.
I think that the trickiest part of everything we've talked about is the letter. And I think we have, as Liz pointed out, until September 25. Maybe between now and then we will get the interim final rule, which will give us a much better idea of what is illegal DE&I and what are your obligations. But I think employers, especially federal contractors, should be thinking about this with their counsel as soon as they can and start thinking about what they're going to do.
Liz?
To that end, I know we've talked about this on prior webinars and podcasts with you. If you have not taken a review of your DE&I processes yet, you need to be doing that, because even if you choose not to respond to this voluntary, we don't know what's going to come out. Anybody who doesn't respond, you may be subject to targeted for deeper review and then forced to respond to that. So wanting to make sure that everybody is taking a look at their DE&I programs and are comfortable responding either voluntarily or when forced to do so as a result of an investigation by one of the agencies.
Those are good advice. I'll build on that. And then I want to just talk a little bit about some of the other resources that people can go to help them understand these issues. So first of all, my view is evolving to the point that I'm beginning to think that some response general is almost a default to no response. I think that's better, because
I agree.
I'd rather deal with whatever comes down the pike after September 25 by arguing about the quality of the response, or it wasn't enough. And by the way, I'm not suggesting submitting workforce data, et cetera, but I think it's always a little riskier to be perceived as ignoring opportunities. And the experience I'm gained with this administration, engagement doesn't have to be full engagement, but some level of engagement can often do you well, because then you're at least arguing about, okay, I didn't give you workforce data because I was concerned about how the confidentiality of it, and I might put that in my response, that it's not clear how the confidentiality of my data will be maintained in this, but I can assure you, you can point to things on your website that are all public information. Most everyone that we've worked with has done a great deal of effort to reimagine their website and their public facing statements. Many organizations have placed statements to the SEC and other regulatory agencies describing changes they've made. So there's a lot of things you could, if you will, recycle, provide a response, but not give away the company's store. So,
and I, to echo David's sentiment, this administration doesn't want to be ignored. And I think not responding and providing nothing, I don't think will be viewed favorably.
yeah. Well, let me just take a moment and highlight for those of you that maybe haven't visited. We do on our website, www.fortneyscott.com, have what we call a resource page. It's right there for you. It lays out what's there. We also do a podcast, DC Insider Employer Update, where we cover a lot of information. We're going to do a podcast involving some of these topics. The last podcast was, I thought, a very interesting discussion on a new proposal for a special court, a new court to adjudicate NLRB claims, a labor law court that's being proposed and discussed. So there's a lot of things going on. It is challenging, but this is one of the most exciting times in terms of EEO compliance, workplace law compliance in our careers. And so we're riding the wave, but there's a lot of information we've uploaded on our website. We would encourage you to join that. Obviously, if you've got questions, etc., we're happy to help you, and we appreciate everyone joining us today. Thanks. Hey, Sarah, I see you're on. We must be out of time.
Hi, David. Thanks. We'd like to thank you all for joining us today. If you have any further questions, please email us at info@fortneyscott.com. A recording of this webinar and a copy of the PowerPoint will be available to all those who attended. This will be sent as soon as the webinar recording is available. Stay tuned for our next podcast and webinar.
Thanks, everyone.